Hey, thank you for being here today. We are going to go through the California Residential Purchase Agreement. This is a really long document. There's about 17 pages of the actual purchase contract, and there are attached addenda that will go with every transaction that you use this document in. So we're going to go through everything today. So all of the information presented in this training has been compiled and provided by your broker in charge, which is Kevin. And, while we've made every effort to ensure that everything is accurate, please do double check everything. And if you have any questions, do not hesitate to reach out to Kevin or to our support team. That is going to be support@daltonwade.com. So the first document we have is the disclosure regarding real estate agency relationship. This is a required document and it's 2 pages long. So this is going to be the first thing that you go through with your clients. This is a required disclosure explaining agency relationships. You want to make sure that your client understands who represents whom and what fiduciary duties do exist and how dual agency works. So a seller's agent only represents the seller and uses a listing agreement. They owe the seller loyalty, utmost care, integrity, honesty, and confidentiality. They owe both the buyer and seller diligence in reasonable care, good faith, fair dealings, and disclosure of all known facts materially affecting the property. The buyer's agent only represents the buyer. They use a buyer-broker agreement, and they owe the buyer loyalty, utmost care, integrity, honesty, and confidentiality. They owe both the buyer and the seller diligence in reasonable care, good faith, fair dealings, and disclosure of all known facts that materially affect the property. The agent representing both the buyer and seller, so that would be a dual agency situation. It's one brokerage, right, representing both the buyer and the seller, and this limits what the agent can disclose. Both the buyer and the seller must consent to this possibility in writing. In representing both the seller and the buyer, a dual agent may not, without the express permission of the respective party, disclose to the other party confidential information, including but not limited to the buyer's or seller's financial position, motivations, bargaining position, or other personal information that might impact the price, including the seller's willingness to accept a price less than the listing price, or the buyer's willingness to pay a price greater than the price offered. The seller and buyer's responsibilities. So this section here explains that even though agents have fiduciary duties, buyers and sellers are still responsible for protecting their own interests throughout the transaction. Buyers and sellers must confirm who their agent represents and whether the agent is acting exclusively or as a dual agent. Clients should carefully read all agreements to ensure they understand everything. And an agent provides real estate guidance, but does not replace legal or tax professionals. Buyers are responsible for exercising reasonable care to protect themselves, which includes paying attention to facts about the property that are known or reasonably observed. Both buyers and sellers are encouraged to seek independent tax advice, as tax consequences can be complex and can change over time. Clients might receive the disclosure more than once if multiple agents are involved, and they should review it each time. The law requires any agent with more than a casual relationship to provide this disclosure. So this is page 2. So a lot of text here. I'm going to kind of break it down on the right. Pretty hard to read on the left. So when you guys do go through this document, just make sure you do read it carefully. But at the top, 2079.13. So for purposes of this article, agency disclosure law, specific key terms are defined so that everybody understands exactly what they mean in a real estate transaction. So it defines agent as a person acting under Chapter 3 of the Business and professions code, meaning a licensed real estate broker or salesperson acting in a real estate transaction for compensation. It clarifies that a salesperson acts on behalf of their employing broker and establishes that when a broker or salesperson owes a duty to a buyer or seller, that duty applies whether the agent is acting in a casual, temporary, or formal agency capacity. It defines buyer as a person who is seeking to acquire real property or interest in real property. It defines a seller as a person who is seeking to transfer real property or an interest in real property. It defines listing agent as a person who has obtained a listing agreement from a seller to act as the seller's agent. It defines selling agent as a person who acts as the agent for the buyer, even though historically that term often meant the agent who sold the property. Dual agent means an agent who represents both the buyer and the seller in the same transaction. And it defines key terms related to real property, including residential properties, which are 1 to 4 units. 2079.14. So when this disclosure is required. So this law explains when an agent must give this disclosure. Agents must give it as soon as practicable when discussing a real estate transaction. It must be provided before entering into a listing agreement or a buyer representation agreement. And the disclosure must be given again if agency relationships ever change. So 2079.15. So this section explains who gives the disclosure to whom. A seller's agent must give the disclosure to the seller before signing a listing agreement. A buyer's agent must give the disclosure to the buyer before signing a buyer representation agreement. If both parties are represented, each agent must ensure their client receives the disclosure. If a party refuses to sign, the agent must document the refusal. 2079.16, confirmation of agency relationship. So this section requires confirmation. So the purchase agreement or another written document must clearly state who the agent represents and whether the agent is acting as a dual agent. This confirmation must be in writing and acknowledged by the parties. 2079.17, agent duties. So this section explains, agents owe fiduciary duties to their clients. Agents must act with honesty, loyalty, and reasonable care. These duties do not remove the responsibility of buyers or sellers to protect their own interests. 2079.19. So compensation does not determine agency. When an agent represents a seller, the agent must disclose to the buyer whether they are acting as the seller's agent or the buyer's agent or a dual agent. And if the agent is acting as a dual agent, both the buyer and seller must provide informed written consent. 2079.2. An agent may choose a specific type of agency relationship as long as it is not prohibited as a condition of employment, provided the statutory disclosure requirements are followed. Agents can structure their agency model, but they must comply with required disclosure laws. 2079.21. A dual agent cannot disclose confidential information without permission, right? And we just kind of talked about this, but specifically, cannot disclose the seller's confidential information to a buyer without the seller's permission, and they cannot disclose the buyer's confidential information to the seller without the buyer's permission. Confidential information includes financial position, motivation, bargaining position, willingness to accept less or pay more, and this section does not eliminate broader fiduciary duties regarding confidentiality. A key point here is that dual agents must strictly protect both parties' confidential negotiating information. 2079.22. An agent may represent both the buyer and seller in the same transaction. If one party chooses not to be represented, that alone does not automatically make the agent a dual agent. Dual agency is allowed, but lack of representation on one side does not automatically create dual agency. 2079.23. This section explains the agency relationship can be changed at any time before the agency task is completed, but only with written consent from the parties involved. A lender or auction company cannot require a homeowner or listing agent to indemnify or defend them as a condition of approving the transaction. Any clause requiring that is void and unenforceable. And a key point, agency can be modified with written agreement, and lenders cannot shift liability onto agents or sellers through improper indemnity clauses. 2079.24. Nothing in this article reduces or limits the agency's duty of disclosure or fiduciary obligations. Agents remain fully liable for breach of fiduciary duty, failure to disclose, misconduct related to the transaction, and a key point is that these statutes do not weaken an agent's legal responsibilities. All right, now we are getting into page 1 of the purchase contract. This is called the California Residential Purchase Agreement and Joint Escrow Instructions. So up at the top, 1A is the buyer identification. So this identifies the legal buyer or buyers making the offer. So you're going to enter their full legal name exactly as it will appear on title. Then we have the property description. So this legally identifies the property by address and APN. Verify that it's accurate before submitting. The terms of purchase. This states that all contract terms are contained in this agreement and its attachments, and you want to ensure that all referenced addenda are attached and included. 1D is the parties. So this clarifies that only the buyer and seller are parties to this contract, and this confirms the seller's names, that it matches the title records exactly. 2A is the agency disclosure confirmation. So this confirms that the statutory agency disclosure form was provided. Deliver and obtain acknowledgement of the agency disclosure form before presenting the offer. 2B is the brokerage firm. So this identifies which firm represents the buyer and seller and whether dual agency exists. So you want to fill in the correct brokerage name, license numbers, and check the proper representation boxes. 2C, multiple brokerage representation. So this states whether one brokerage or separate brokerages represent the parties. 2D, compensation. So this confirms the buyer received the broker compensation disclosure. This provides the required disclosure form and retains the documentation. 3A is the purchase price. So this states that the total price being offered for the property, so whatever that is, please enter that, the full purchase price, and must be confirmed that it aligns with the financing terms. All right. And then at the very bottom, we have the buyer and seller's initials. So this just confirms that everything written above is correct. All right, perfect. I missed a page there. So, okay. 3A, you're going to enter the purchase price, right? So total price being offered. Enter the full purchase price. And then 3B is going to be the close of escrow. So this specifies how many days after acceptance escrow will close. Confirm the timeline with the lender before drafting. 3C is the expiration of offer. This sets the deadline for the seller to accept the offer. So you want to enter a clear date and time. 3D1 is the initial deposit. So this specifies the earnest money amount and when it must be delivered. 3D2 allows for an additional deposit later in the transaction. So attach the increased deposit addenda if this option is being used. 3E1 is the loan amount. This is going to detail the buyer's primary financing terms and loan contingency period. You want to verify the loan pre-approval and insert the accurate contingency days. 3E2 is the additional financing. So this covers any secondary loan or seller financing. So you only want to complete this if it applies. 3E3 is the occupancy type. So this indicates whether the buyer will occupy the property as a primary, secondary, or an investment. So confirm that the occupancy aligns with the lender approval. That's really important. 3F is the balance of the down payment. So the buyer's cash contribution toward the purchase, you want to verify that and ensure that all proof of funds supports that amount. And then the purchase price total. So this confirms the total offered purchase price. Double check your calculations, make sure everything adds up, and then buyer and seller are going to initial at the bottom. Then we have G1, which allows the seller to credit the buyer a specified dollar amount towards closing cost. Enter the agreed credit amount and confirm it aligns with the lender limits. G2 provides additional space for additional seller credit terms. G3 allows the seller to agree to pay the buyer's broker a specified amount or percentage from the proceeds. So complete this section only if the seller is agreeing to compensate the buyer's broker. H1. This states when proof of sufficient cash funds must be provided. Attach proof of funds with the offer or specify the number of days after acceptance for delivery. H2 is verification of down payment and closing. So specifies when verification must be delivered, and you want to attach documentation with the offer if you have it, or indicate the agreed time frame. H3 states when proof of loan application must be submitted and the level of pre-approval. This indicates whether it is a pre-qualification, a pre-approval, or a fully underwritten approval. This is left blank. J, final verification of condition. So this provides the time frame for the buyer's final verification of the property condition before closing. Enter the agreed number of days prior to close of escrow. K is assignment request. So this states whether the buyer may assign the contract and within what time frame. So you're going to specify the number of days allowed if assignment is going to be permitted. L1 gives the buyer a specified number of days to secure financing approval. Enter the agreed contingency period or check no loan contingency if waived. L2 allows the buyer time to ensure the property appraises at or above the purchase price. You're going to enter the agreed time frame or check no appraisal contingency if waived. L3 gives the buyer a specified number of days to conduct inspections and property investigations. And then informational access to property allows the buyer to access the property for informational purposes after the contingency removal without creating new cancellation rights. No timeline entry is required unless otherwise negotiated. L4 is insurance. This allows the buyer time to obtain acceptable insurance coverage. Enter the agreed number of days there. L5 provides time for the buyer to review the seller provided disclosures and documents. L6 gives the buyer time to review the preliminary title report. You're going to enter that number of days there. L7 applies to properties in an HOA or a common interest development, and it allows review time. So insert the agreed upon time frame for that document review. L8 allows the buyer time to review leased or liened items such as solar panels. L9 makes the purchase contingent on the sale of the buyer's existing property unless waived. So attach the appropriate addendum if this contingency applies. Super important that you get that one. Removal or waiver of contingency. So This section explains how contingencies may be removed in writing. Use the appropriate removal form when contingencies are satisfied. M1 explains when the buyer takes possession, typically at recording or a specified date or time. So clearly indicate AM or PM if possession differs from recording. M2 addresses whether the property will be vacant at closing or remain occupied. Specify the agreed possession timing if it's different from recording. M3 applies when tenants or others occupy the property. Attach a tenant-occupied property addendum if required. N1. This sets the time frame for the seller to deliver required documents. Enter the agreed number of days after acceptance. N2 provides the time frame for signing and returning escrow instructions. Insert the agreed number of days after delivery. N3 specifies the time frame for ordering or delivering HOA documents if applicable. N4 requires installation of smoke alarms, carbon monoxide detectors, and water heaters as required by law. So confirm compliance prior to closing. N5 requires proof of authority if a party is signing on behalf of another property. Provide documentation within the specified time frame. P. So this is items included or excluded. So this section is going to list all the fixtures and personal property included in the sale unless excluded. So review all of the checked items carefully and confirm inclusions match the buyer's understanding and the MLS description. Additional items included. So this is just a space to add items that are not already on the list. You want to clearly write them out to avoid disputes. P2. This section is going to identify any items that the seller is excluding from the sale. So you're going to list the exclusions specifically and ensure they are disclosed to the buyer before acceptance. Q. Allocation of costs. Q1 specifies who pays for the natural hazard disclosure report. So you're going to select buyer, seller, or both, and then confirm who's responsible for ordering it. Q2 indicates who will pay for the wildfire disclosure report, if applicable. Q3 allows allocation of additional reports not otherwise listed. So remember, you want to identify the report and then select who will be paying. Q4, this assigns responsibility for required safety compliance costs for smoke alarms, CO detectors, and the water heater bracing. Q5, this assigns responsibility for required local inspection reports. So select the responsible party, and you want to verify local compliance requirements. Q6 determines who will pay for repairs required by government inspections. Q7 allocates escrow fees between the parties. Check the agreed allocation or specify if each party will pay their own. Q8 assigns responsibility for the owner's title insurance policy. Select the paying party and confirm the title company. Q9 states that the buyer pays for the lender's title policy unless otherwise agreed. Okay, so confirm that this aligns with the lender's requirements. Q10 specifies who pays the county transfer tax. So you want to select and then make sure that you check out the local custom, all that. Q11, this allocates responsibility for city transfer taxes. Q12 states that the seller pays the HOA document preparation fees unless otherwise agreed. Q13 assigns the HOA certification fee to the buyer. Confirm with escrow if certification is required. Q14, this allocates HOA transfer or move-out fees. Q15 assigns responsibility for any private transfer fees if applicable. So verify whether such fees exist before checking the box. Q16 provides space to allocate additional unspecified costs. You want to clearly describe what that fee is and then select who pays. Q17 is just a secondary space for any other negotiated fees. Q18 allows the parties to agree on purchasing a home warranty. Who will pay? So you want to check the paying party and insert the maximum cost if applicable. R is other terms. So this section allows the parties to add any custom terms not covered elsewhere in the agreement. You want to write those additional terms very clearly and specifically. Buyer and sellers will initial on the bottom of the page. Number 4. So this is the property addenda. So this section identifies required addenda based on the property type, if it's tenant occupied, if there's probate, manufactured home, all of that stuff. So you want to check every single addenda that applies and make sure they are attached to the offer. 4B is any other addenda. So just make sure to pay attention to that. You know, if it's a short sale, if there's a septic system, all of that. 4C, this section acknowledges receipt of advisory forms provided for informational purposes only. So check that the advisories were delivered, confirm that they are not incorporated into the contract unless previously stated. 5A, this section explains how and when the buyer's deposit must be delivered and how it is treated in the event of buyer default. Confirm the deposit method and ensure the buyer understands forfeiture limits under California law. 5A1 states that the buyer must deliver the deposit directly to escrow using the specified method. Ensure the deposit method complies with escrow instructions and contract terms. 5A2, this limits how much of the deposit the seller may retain if the buyer defaults. Do not alter the deposit forfeiture language beyond statutory limits. 5B states that no loan is required if the offer is all cash. Confirm proof of funds, demonstrate sufficient cash to close. And we have buyer and seller initials at the bottom of the page. 5C. So 5C1 explains that the loan's primary loan, that the buyer's primary loan must match the financing terms specified elsewhere in the agreement. 5C2 applies if there is any secondary financing. 5C3 clarifies that loan approval is a contingency only if one is specified in the contract. 5C4, so this incorporates FHA or VA addenda when applicable, and it sets requirements for appraisal and repairs. So you want to make sure to attach those addenda if this applies. 5D, this explains how the remaining funds must be deposited into escrow prior to closing. Confirm the buyer understands timing and funding requirements. 5E, this limits the total buyer credits to the lender approved amount and explains how excess credits are handled. 6A, this requires written verification that the buyer has sufficient funds. So you want to obtain and submit the lender acceptable documentation within the required time frame. 6B, this requires proof that the buyer has applied for the loan. Submit a lender letter confirming application within the specified number of days. 6C states that the seller relies on the buyer's stated financing and that alternate financing does not relieve the buyer of the obligation to close. Ensure the buyer understands that failure to obtain alternate financing is not an excuse to cancel unless a contingency applies. 7A is occupancy. So this section states that if the buyer intends to occupy the property as a primary or secondary residence, possession will be delivered at close of escrow unless otherwise agreed. 7B states that the property is sold in its present as-is condition, subject to the buyer's investigation rights. Ensure the buyer understands that condition at closing must be essentially the same as at acceptance, right? 7C, this advises the buyer to conduct investigations to determine the property condition and compliance, contract compliance. You want to encourage the buyers to complete all of those inspections, and it must be within the contingency timeline. 7D states that the seller remains in possession after closing. A separate written agreement is required. So that's going to be, you want to use the appropriate rent back or post-closing occupancy agreement. So that would be a very specific situation. Just double check on that. 7E, at close of escrow. So this confirms that the seller assigns warranties and delivers keys and access devices to the buyer unless otherwise agreed. You want to verify that all of the keys, remotes, warranties, all of them have been transferred by closing. 7F. This clarifies that if the seller remains in possession, the seller retains responsibility for maintenance and utilities unless otherwise agreed. Use the proper addendum and clarify utility responsibility in writing. 8A1, this is loan approval. This makes the purchase contingent upon the buyer obtaining the specified loan within the stated time frame. Ensure the loan contingency timelines are realistic and being monitored very closely. 8A2, this clarifies that lender-required investigations are part of the buyer's loan process, so confirm the buyer completes the lender conditions promptly. 8A3 allows cancellation if the buyer cannot obtain required insurance during the contingency period. Confirm insurability early. 8A4 states that removing the loan contingency does not automatically remove the appraisal contingency. 8A5, if checked, obtaining financing is not a condition of this agreement. So ensure the buyer understands that they must close regardless of financing outcome if this is checked. 8B, or 8B1 rather. This makes the purchase contingent upon an appraisal at or above the purchase price unless otherwise stated. 8B2, if checked, the buyer cannot cancel solely due to low appraisal. 8B3, this explains that appraisals must be unbiased and free from discrimination. And then everybody is going to initial. 8C, investigation of the property. So this makes the purchase contingent upon the buyer's acceptance of the property's condition and any other matters affecting it. 8D makes the agreement contingent upon the buyer's ability to obtain property insurance. 8E makes the agreement contingent upon the buyer's reviewing and approving of the seller's disclosures. 8F1 makes the agreement contingent upon the buyer's review and approval of the preliminary title report. 8F2 allows the buyer to cancel if a revised title report reveals new material issues. 8G makes the agreement contingent upon the buyer's review of HOA or common interest development documents. 8H makes the agreement contingent upon the buyer's review of leased or liened items, such as solar panels. 8I states that contingencies remain in effect until formally removed in writing. So use the proper contingency removal form when the buyer intends to remove them. 8J1, this requires the buyer to remove the loan contingency in writing within the specified time frame or cancel. 8J2 requires the buyer to remove these contingencies within 5 days of delivery or cancel. 8J3 allows the seller to issue a notice to perform if the buyer fails to act. 8K states that the purchase is not contingent upon the buyer selling another property unless the appropriate addendum is attached. So you're going to attach the sale contingency addendum if applicable. 9A clarifies that MLS listings and marketing material do not determine what is included in the sale. You want to specify what's included or excluded directly in the contract. 9B1 states that permanently attached fixtures transfer with the property. Confirm all fixtures intended to remain are properly in the contract. 9B2, so this further details any attached systems or fixtures. You want to verify that information. 9B is the security systems. So the security system and any related equipment are included if checked. 9B4, this includes integrated smart devices if checked. 9B5 clarifies that portable or non-integrated devices are excluded unless specified. 9B6. So this requires the seller to disclose if any included items are leased or subject to liens or other obligations and to provide related documentation. Confirm all leased items, such as solar, are disclosed and the supporting contracts are delivered. 9B7 states that the included items will transfer free of liens except for those specifically identified. You want to verify the payoff information for any leased or financed items prior to close. 9C clarifies that certain equipment or components not attached to the property are excluded unless specifically included. 10A states that the contract does not determine who pays for recommended or required work unless specified elsewhere. Clearly allocate responsibility for inspection-related costs in the appropriate section. 10B1 states that required safety installations or corrective work must be completed and paid by the party specified in the contract. 10B2 addresses required inspections or repairs mandated by local ordinances prior to closing. So you want to verify whether local point of sale requirements apply, and you want to track compliance deadlines closely. 10B3 explains that if repairs are not completed in time and reinspection is required, the responsible party must pay those associated fees. 10B4 advises the parties to consult knowledgeable professionals regarding legal compliance and obtain expert advice if needed. 10C1. This allows the buyer to purchase a home warranty plan and allocate payment as agreed. You want to specify the coverage amount and confirm the provider if selected. 10C2 allows the buyer to waive the home warranty purchase. 11A1 requires the seller to provide all statutory disclosures, including the transfer disclosure statement and natural hazard disclosure. Deliver all required disclosure forms promptly and track the buyer's acknowledgement. 11A2 confirms the seller must complete and deliver the TDS and related statutory disclosures. Ensure that the transfer disclosure statement is fully completed, signed, and delivered before the contingency deadlines expire. 11A3 is the seller property questionnaire, so the SPQ, requires the seller to complete and deliver the SPQ if applicable. Ensure the SPQ is fully completed, signed, and delivered within the required timeframe. 11A4 requires the seller to promptly provide amended disclosures if new material facts are discovered before closing. 11B applies to residential properties built before January 1st, 1978, okay? So it requires the delivery of the lead-based paint disclosure and pamphlet. You want to confirm that the buyer has received and signed acknowledgement of the disclosure if this applies. 11C applies to certain high fire hazard severity zones and requires disclosure regarding defensible space and fire hardening compliance. 11D applies to properties in high or very high fire hazard severity zones. You want to provide required defensible space documents, attach it, and any applicable addenda as well. 11E advises buyers that an electrical inspection may be required, may be recommended. Inform the buyers of potential risks and recommend professional inspections if appropriate. 11F states that statutory disclosures cannot be waived when required by law. 11G requires the buyer to return signed copies of disclosures within the specified timeframe. 11H gives the buyer the right to cancel within a specified period after delivery of all required disclosures. 11H2 clarifies that the buyer does not agree to compliance terms unless specified and retains rights regarding defensible space matters. 11I addresses potential federal and state withholding requirements for certain sellers. You want to confirm whether withholding applies and obtain the required affidavits before closing. 11J provides notice regarding availability of registered sex offender information online. So you want to advise the buyers to independently research that database if they have any concerns. 11K provides notice that information regarding pipeline locations is available through public resources. So recommend that the buyers review available government mapping resources during their investigation period. L requires the seller to deliver legally required hazard disclosures, including earthquake, flood, and fire hazard. M1 requires disclosure of if the property is part of a condominium or a planned development. So confirm whether the property is in an HOA or a CID. M2 requires the delivery of HOA governing documents, financials, pending litigation, and any related information. So order and deliver the HOA documents promptly, and you want to track the buyer's review period. N requires disclosure of information about solar panels or systems. O requires compliance with inspection laws for elevated exterior elements when applicable. P requires the seller to disclose known material facts affecting the property, including prior insurance claims. 12A grants the buyer the right to conduct inspections and investigations at the buyer's expense unless otherwise agreed. So you want to advise the buyer to schedule inspections early and within the contingency time period. 12B allows inspections of physical conditions, including pest inspections and environmental hazards. 12B2 permits additional inspections of land or improvements as needed. 12C requires the seller's consent for the buyer's access and outlines conditions for entry. 12D requires the buyer to repair any damage caused by inspections and to maintain utilities. 12E requires the buyer to indemnify the seller for certain damages arising from investigations. 13A requires the buyer to review after receiving the preliminary title report. And then everybody will initial at the bottom. 13B, title will transfer in its present condition, subject to existing easements, restrictions, and other recorded matters, except monetary liens to be paid at closing. 13C, the seller must disclose all known title matters affecting the property. 13D, certain all-cash transactions may require federal reporting of buyer identity under Treasury rules. So confirm whether the transaction triggers reporting requirements and cooperate with escrow if required. 13E, the seller must deliver requested information needed to clear title. You want to ensure that all required payoff or lien documentation is provided promptly. 13F, the buyer will receive title by grant deed or other applicable conveyance and vest according to the buyer's instructions. 13G, The buyer will receive a standard or Alta-owned title policy unless otherwise selected. Confirm the policy type and ensure issuance of title insurance at closing. Tongue twister. 14A, the seller must deliver required disclosures and reports within specified timeframes. Track the delivery and dates carefully. 14B1, the buyer has a specified period to review disclosures and reports. 14B2, the buyer may request repairs based on inspections or disclosures. You want to submit repair requests in writing within the contingency period. 14B3, the buyer must remove contingencies in writing by the deadline, or the seller may issue a notice to perform. 14B4, if contingencies are not removed and seller does not cancel, the buyer retains the right to cancel. 14C1, the seller may cancel if the buyer fails to remove contingencies after proper notice. 14C2, the seller may cancel if the buyer fails to meet contractual obligations, such as deposits, loan applications, or documentation delivery. 14C3, the seller may cancel based on certain contingencies, if applicable, and not previously removed. And then everybody will initial. 14D, the buyer may cancel if the seller fails to remove applicable contingencies within the required timeframe. 14D2, the buyer may cancel if the seller fails to deliver required documents or perform contractual obligations. 14D3, the buyer may cancel based on any valid contingency that has not been removed or waived. 14E specifies how and when a notice to perform must be delivered to enforce deadlines. 14F1, once the buyer removes contingencies, the buyer is committed to proceed and assumes related risks. 14F2, once the seller removes contingencies, they are committed to proceed and assumes related risks. 14G allows either party to demand closing once contingencies are removed and escrow is ready. So deliver the demand to close escrow form properly and within specified timelines. 14H outlines how deposits are handled if the agreement is canceled. You want to confirm escrow instructions and obtain mutual cancellation instructions if required. 15A, repairs must be completed in a workmanlike manner and in compliance with applicable law. So you want to obtain invoices, permits, and receipts for all repairs. Number 16, the buyer has the right to conduct a final walkthrough before closing. So you want to schedule the final verification within the allowed time frame prior to close. 17, property taxes, HOA dues, rents, and other recurring costs will be prorated as of close of escrow unless otherwise agreed. And then everybody will sign. 18A1, the seller or buyer, as agreed, will pay broker compensation as specified in a separate agreement. Confirm the compensation terms are documented in writing. 18B, the broker's duties are limited to those defined by law and do not include guaranteeing property condition, price, or future performance. You want to advise your clients to conduct independent inspections and obtain professional advice as needed. 19A, agreement serves as joint escrow instructions to the escrow holder. Ensure that escrow receives a fully executed copy of the agreement promptly. 19B, escrow holders' duties are limited to those specified in escrow instructions. 19C, authorizes escrow to use copies and electronic signatures, and it clarifies compliance with federal reporting requirements. 19D1, escrow may disperse broker compensation from closing funds if instructed. 19D2 requires disclosure of broker compensation to the seller and others as required by law. 19E Escrow may require invoices for expenses prior to close. 19F, escrow will verify receipt of buyer's deposit and notify the agents if refunds are not received or dishonored. 19G, amendments affecting escrow must be delivered to escrow within 3 days of execution. And then everybody will initial. 20, agents do not guarantee the performance of vendors selected by either party. 21, agents may report offer and closing information to the MLS, and property information may be publicly distributed. So inform your clients that listing data may remain publicly accessible even after close. 22, in legal disputes arising from the agreement, the prevailing party may recover attorney's fees unless otherwise agreed. 23, the buyer may assign the agreement only if allowed and under specified conditions. 24, agreement may be assigned by a legally authorized representative on behalf of an entity. 25, acceptance offers when a signed offer or counteroffer is delivered to the other party. So that's when acceptance occurs. So when it's delivered, so you want to track delivery, make sure that you're really on top of that. You want to make sure that the contractual deadline begins on at a specific time. 25B. So the term agent refers to the licensed real estate professional involved in the transaction. 25C, agreement includes the purchase contract and all incorporated addenda and counteroffers. 25D, as is, means that the property is sold in its present condition, subject to the buyer's investigation rights. 25E, so this is the authorized agent term, so it refers to the specific real estate licensee representing a party. 25F, the CAR form refers to the specified version of the California Association of Realtors form. 25G, close of escrow occurs when the deed is recorded. 25H, copy. The term copy includes electronic and recorded versions of documents. 25I, so deadlines are calculated based on calendar days unless otherwise specified, with special rules for delivery timing and weekends. 25J, day means calendar day unless otherwise specified. This is except for deposits which are based on business days. And then buyer and sellers will initial at the bottom. 25K, delivery. So that's defined, defines what constitutes proper delivery of documents, includes personal delivery and electronic delivery. 25L allows use of electronic copies and signatures in compliance with California law. 25M specifies that the agreement is governed by applicable laws and regulations. 25N defines legal action as lawsuits, arbitration, or any other proceedings. 25O clarifies that a legally authorized signer may execute documents on behalf of a principal. 25P confirms that changes to default terms must be agreed to in writing and delivered to both parties. 25Q clarifies that repairs include alterations, replacements, retrofits, and similar corrective work. 26 affirms compliance with federal, state, and local fair housing laws. 27 explains that the agreement incorporates all terms and attachments and becomes binding upon acceptance. So you want to confirm that all addenda and counteroffers are attached and executed before acceptance. 28 states that the time is of the essence and that the written agreement contains the entire contract between the parties. And everybody will initial. Number 29 limits the seller's damages to 3% of the purchase price if the buyer defaults. Number 30. 30A requires parties to attempt mediation before filing a lawsuit or arbitration, except for certain limited actions. 30B clarifies that mediation obligations and exceptions related to preservation of rights. So review the related contingency and cancellation provisions. And then number 31A provides that disputes may be resolved through binding arbitration if both parties initial the provision. 31B lists certain matters excluded from arbitration, including small claims and certain judicial foreclosure actions. 31C allows parties to file certain legal actions, such as recording a lis pendens or seeking injunctive relief without waiving arbitration rights. So ensure that legal counsel is consulted before filing such actions. 31D clarifies that brokers and agents are not automatically parties to arbitration unless they agree in writing. So you want to confirm whether the agents are included in arbitration agreements. 31E explains that by initialing, parties waive the right to a jury trial and agree to binding arbitration. And then everybody will initial. 32A, offer is revoked if not accepted and delivered by the date specified in paragraph 3C. So track the expiration deadlines carefully. 32B1 requires disclosure when the buyer is a trust, corporation, LLC, estate, or other entity. Confirm the correct entity name and that the capacity is clearly written. 32B2 requires the full legal name of the entity to be inserted. 32B3 clarifies how the buyer will be referenced throughout the agreement. 32B4 requires the individual signing on behalf of the entity to sign in a representative capacity. 32C, the buyer acknowledges receipt and understanding of all pages and attachments. 32D, the buyer must sign and date the agreement in the appropriate capacity. Ensure that all required signature lines are completed and titles are included when signing as an entity. 33A, the seller accepts the offer and agrees to sell under the stated terms. 33B1 requires disclosure when the seller is a trust, corporation, LLC, estate, or other entity. 33B2 requires insertion of the full legal name of the selling entity. 33B3 clarifies how the seller will be referenced in the agreement. 33B4 requires the authorized individual to sign in representative capacity. 33C, the seller acknowledges receipt and understanding of all pages and attachments. 33D, the seller must sign and date the agreement in the appropriate capacity. And additional signature addendum. So additional signature forms must be used if more than 2 buyers or sellers are signing. So you want to attach the appropriate addenda if it applies. All right, real estate broker section. So confirm that the brokers are not parties to the purchase agreement between the buyer and seller. Number 2, confirm agency relationships as previously disclosed. Number 3 requires documentation that the buyer's agent presented the offer to the seller in accordance with realtor standards. 4A identifies the buyer's brokerage firm, agents, license numbers, and designated electronic delivery addresses. Additional agent acknowledgments for the buy side requires disclosure if multiple agents or brokerages represent the buyer. 4B identifies the seller's brokerage firm's license numbers and designated electronic delivery address, and the additional agent acknowledgments for the seller side requires disclosure if multiple agents or brokerages represent the seller. Escrow holder acknowledgement. So the escrow acknowledges receipt of the agreement and agrees to act under its terms. Ensure that escrow signs and provides the escrow number and license information. The escrow must indicate appropriate regulatory authority and license number. And the presentation of offer confirms the date the seller's brokerage presented the offer to the seller. Offer not accepted. So this is used when the seller rejects the offer without making a counteroffer. All right, now we are into the federal reporting requirement purchase addenda. So this addendum exists because the US Treasury now treats certain residential real estate transactions as potential money laundering risks. So historically, criminals could form an LLC, pay all cash, buy residential property, and then hide behind the entity structure. So the federal government has been trying to close that loophole. This form is California's contractual way of forcing cooperation with those federal reporting rules. So this addenda does three important things. Number one, it warns the parties that reporting may be required. Number two, it creates a contractual obligation to provide information. Number three, it makes failure to provide information a potential breach of contract. This is used with all residential purchase agreements when federal reporting rules apply, and that includes residential property with 1 to 4 units, vacant land intended for 1 to 4 units, certain all cash purchases, purchases made by entities, trusts, or similar structures, and transactions that fall under FinCEN's geographic targeting orders, or GTOs. All right, so the next addendum is one of 2 pages. It is the possible representation of more than one buyer or seller disclosure and consent form. Long title. So the PRBS form discloses that a real estate brokerage may represent multiple buyers, multiple sellers, or both, a buyer and a seller in the same transaction. It explains how this can occur within a brokerage that has multiple agents operating under the same broker license. So basically, the document clarifies that a brokerage may represent competing buyers interested in the same property. A brokerage may have multiple listings that compete for similar buyers. Dual agency can occur either when 2 different agents within the same brokerage represent a buyer and a seller, or when one agent represents both parties. So that's brokerage dual agency versus single agent dual agency. In dual agency situations, the agent cannot disclose confidential information such as a buyer's willingness to pay more or a seller's willingness to accept less without written permission. Offers are not automatically confidential unless there is a separate written confidentiality agreement. The client acknowledges and consents to the possibility of multiple representation of dual agency. So this is a risk management document. All right, so this is the Fair Housing and Discrimination Advisory Addenda. This also has 2 pages. So the Fair Housing and Discrimination Advisory explains that federal and California law requires equal access to housing and it prohibits discrimination in all housing-related activities. It outlines protected classes under federal and state law, including race, color, religion, national origin, sex, disability, family status, sexual orientation, gender identity, marital status, source of income, immigration status, and other protected characteristics. The advisory warns that discrimination can occur intentionally or unintentionally and may result in serious legal consequences. So the document emphasizes that agents must treat all clients and applicants equally, avoid steering, discriminatory advertising, or unequal terms, refrain from asking questions related to protected characteristics, follow objective, consistent screening and negotiation practices, complete required fair housing training. So in short, this advisory reinforces that housing decisions must be based on lawful, objective criteria and never on personal characteristics. All right, this is the Buyer Homeowners Insurance Advisory Form. So this explains the importance of obtaining property insurance when purchasing a home, and it warns that insurance availability and costs can affect a buyer's ability to complete the transaction. It advises buyers that property insurance protects against losses from fire, flood, earthquake, and other damage. Lenders require insurance when financing is involved. Buyers may have a contractual right to cancel if they cannot obtain insurance. California's insurance market has tightened, and some insurers have limited or stopped issuing new policies in certain areas. Physical property conditions such as roof age, wiring, plumbing, wildfire risk, or defensible space can affect insurability. And insurance policies may be canceled if minimum standards are not met. So this document encourages buyers to investigate insurance options early, consult a qualified professional, and use the California Department of Insurance resources for guidance. So this is the wire fraud and electronic funds delivery. The wire fraud and electronic funds transfer advisory. Okay. So this document warns buyers, sellers, tenants, and housing providers about the growing risk of wire fraud in real estate transactions. So it explains that hackers can intercept emails, alter wire instructions, and redirect funds to fraudulent accounts. It instructs parties to obtain wire instructions and phone numbers directly from escrow or the housing provider at the beginning of the transaction. Never rely solely on emailed wire instructions. Confirm transfer instructions by calling a known previously verified phone number. Verify routing and account numbers verbally before sending funds. Avoid sending sensitive financial information by email. Use strong passwords, secure Wi-Fi, and secure systems. This is the buyer's investigation advisory. There are 2 pages. So this document explains that buyers are responsible for thoroughly investigating the condition and suitability of a property before completing the purchase. This document advises buyers to conduct professional inspections and investigations, review all disclosures and reports carefully, understand the square footage, lot size, and boundaries may be approximate, investigate structural components, roofs, foundation, plumbing, electrical, HVAC, appliances, and other systems, evaluate environmental hazards, assess risks related to earthquakes, floods, etc., confirm permits, zoning, governmental compliance, and property use restrictions, verify utilities, sewer access, solar system, and lease obligations, investigate neighborhood conditions, safety features, and local regulations. Now we have the California Consumer Privacy Act. So the CCPA explains that California residents have privacy rights regarding their personal information. It informs buyers, sellers, landlords that personal information collected during a transaction may include names, contact information, financial details, etc. And this information may be shared with real estate brokers, MLS services, lenders, escrow companies, websites, and other service providers. Under the CCPA, consumers have rights, including the right to know what personal information is collected, the right to know how it's used, the right to request corrections, the right to request deletion, the right to opt out of certain sales or transfers of personal information, and the right to limit use of sensitive personal information. That is all I have for you guys today. So I am going to stop our recording and I will open it up for questions. If you guys do have any questions, I will direct them to your broker, Kevin, in an email, CC you, so that we can get that answered for you. So I will go ahead and stop sharing, stop recording now.